May I please begin? Thank you, sir. A very good afternoon to all the members of the tribunal and the counsels for the respondents. Before I begin, could it please be confirmed that I'm clearly audible and visible? Thank you, members of the tribunal. Members, the present case is one where we, as the claimants, have suffered enormous losses at the hands of the respondents on two counts. First, the non-delivery of containers 1 to 5, and second, the damage to the cargo in containers 6 to 10, and we believe that we are owed damages for the same. Therefore, we are here today to resolve this dispute between the claimants, Megabank PLC, and the respondents, Erfurt Spedition GmbH. We thank the arbitrators for facilitating this process of dispute resolution, especially in these trying times of COVID-19 when we are forced to speak into screens. I am here today as counsel number 1, and I, along with my co-counsel, shall be representing the claimants. The present dispute has been submitted before the tribunal in accordance with para 2 of the addendum to the bill of lading. Therefore, my client shall accept the decision of the arbitral tribunal as final and binding. Members of the tribunal, over the course of the next 22 minutes, I shall be dealing with issues 1, 2, and 3, and thereafter, my co-counsel shall be dealing with issues 4 and 5 in 18 minutes. We wish to reserve 5 minutes for rebuttals. Unless the tribunal has any specific queries with respect to the factual matrix, the counsel would like to go ahead and mention 5 material facts for this dispute.
Yes.
Thank you, Mr. Arbitrator. In the present case, firstly, it should be noted that the MMT bill of lading was endorsed to and in the possession of the claimants. Secondly, it was a term of this bill of lading under clause 8.2 that it is an obligation of the respondents to deliver the cargo only to the consignees or endorsees of the bill of lading who presents the same in exchange for the goods. Third, however, when the demand for the goods was made by the claimants, the respondents had already delivered containers 1 to 5 to the buyers without obtaining the bill of lading in return. Fourth, under para 1 of the addendum to the bill of lading, it was an obligation of the respondents to maintain the temperature of minus 18 degrees Celsius for the cargo at all times. Fifth, that the goods in container 6 to 10 underwent damage during transshipment and Santos when they were in the custody of the respondents because they were allowed to heat up, and therefore the obligation in para 1 of the addendum was not fulfilled. Therefore, the respondents now seek to impose the claimants seek to impose liability on the respondents and seek damages. Now, if the counsel may proceed with the first submission, that is, the tribunal should consist of a sole arbitrator.
No, first address what is your locus standi to sue, because you are at the highest subrogated insurer suing.
Indeed, Mr.
Don't you
Arbitrator.
think the assured is a necessary party?
Mr. Arbitrator, in that regard, the counsel submits that by virtue of subrogation, the assurer or the insurer has now stepped into the shoes of the insured and is in the position to sue in the name of the insured, and therefore the GVAG, that is the insurer, has the full locus standi to sue the respondents in the present case.
Is there any provision of law of the arbitration, Singapore International Arbitration Act, which allows you to do that? Are you a party to the arbitration agreement?
Indeed, Mr. Arbitrator, that is because the insured party is a party to the arbitration agreement, and that is why, since the insurer has obtained all the rights of the insured, they too can be considered as party to the arbitration agreement and can initiate the arbitral proceedings.
Proceed.
Thank you, Mr. Arbitrator. With regards to the first submission, the counsel seeks to establish that the International Arbitration Act shall govern the arbitration, and consequently, Section 9 of the Act shall prevail over Rule 6.1 of the SCMA rules to provide for a sole arbitrator. In this regard, the counsel shall make a threefold submission. First, that Singapore is the seat of arbitration. Second, that the International Arbitration Act governs the arbitration proceedings.
Where do you get the proposition that Singapore is the seat of arbitration?
Apologies, Mr. Arbitrator, could you please repeat?
Where does it say Singapore is the seat of arbitration?
Indeed, Mr. Arbitrator, for that I request you to direct your attention to page 12 of the hard copy and page 14 of the soft copy of the case study.
Okay.
Here, Mr. Arbitrator, in para 2 of the addendum to the bill of lading, the arbitration agreement or the clause has been provided where the parties have agreed upon SCMA rules for the arbitral proceedings. Rule 22.1 of the SCMA rules states that under these rules, unless the parties have agreed to the contrary, the seat of arbitration shall be Singapore. And moreover, it also provides that the law that governs the arbitral proceedings would be the International Arbitration Act.
Exactly. So now you're basically relying on the SCMA rules, but the SCMA rules also talk about the 3-member arbitral tribunal. So the seat of so you can't on one hand rely on SCMA rules and not rely it on its entirety.
Mr. Arbitrator, the Council does not seek to challenge the use of the SCMA rules in the present case, but merely that Section 9 specifically prevails over Rule 6.1 of the SCMA rules.
But doesn't Section 9 allow, this is subject to the provisions of the arbitration agreement? It's not mandatory.
Mr. Arbitrator, the Council precisely seeks to submit that Section 9 can be considered a mandatory provision and by virtue of Section 15A, Clause 1 of the International Arbitration Act prevail over Rule 6.1. In order to establish...
You're an Indian law student, what's the position in the Indian law? If there's no agreement between the parties to an arbitration, to the constitution of arbitral tribunal, what's the position in the Indian law?
Mr. Arbitrator, under the Indian Arbitration Act, the position is that the Council believes that the provision is there for a sole arbitrator.
I'm sorry, can you repeat? In absence of an agreement, it's mandatory that it's sole arbitrator. Is that your case?
Mr. Arbitrator, the Council is not completely familiar with that position since the Indian Arbitration Act is not relevant to the present case. However, the Council can revert with that answer in a few moments with the help of the researcher. That is fine.
Okay.
Thank you, Mr. Arbitrator.
My point is Singapore's position is similar to Indian law, which is that it is subject to the agreement. The default position is a sole arbitrator, but nothing stops the parties from agreeing to a 3-man arbitral tribunal. In your case, your rules expressly state for it's a 3-man arbitral tribunal, and hence we'll have to reconstitute the tribunal. We can't proceed with the hearing today.
Mr. Arbitrator, in that regard, the Council submits that Section 9 should be considered a mandatory provision.
Why?
Indeed, Mr. Arbitrator, that is because if we look at the words of Section 9, they state that notwithstanding Article 10.2 of the model law, unless the parties determine the number of arbitrators, there shall be a sole arbitrator. Therefore, it's wording...
Haven't the parties determined the number of arbitrators?
Mr. Arbitrator, no, the parties have not determined since in the arbitration clause of the agreement, it is impossible to read any number of arbitrators that have been agreed between the parties. And
but
therefore,
since this agreement in light of incorporating the arbitral rules, it says that it would be 3 as a default position.
Mr. Arbitrator, in that regard, the Council submits that Section 9 seeks a specific number of arbitrators and express agreement as to the number of arbitrators and merely adopting rules. Yes, Mr. Arbitrator.
Yes, proceed. I'm sorry.
Yes, Mr. Arbitrator. The Council was saying that merely adopting rules of arbitration does not lead to the express determination of the number that Section 9 seeks. And if you could please refer to page number, just a moment. If you could please refer to page number 3 of the arguments advanced in the written submission.
Yes.
You may please refer to citation number 17 and 18, based on which the Council submits that Section 9 requires the determination of a specific number of arbitrators in the arbitration agreement, and the same has not been.
Can you read the SCMA rules, please, on this regard? So, I'm sorry, my apologies. You want me to look at page 3, and which line on page 3?
Mr. Arbitrator, you may please refer to citation or footnote number 17 and 18.
Yeah, but these are some books what you quoted. You quoted a case of Inshu Corporation versus. Okay, now
Yes, Mr. Arbitrator. So keeping in mind these sources where it has been said that Section 9 requires a specific number of arbitrators to be determined, the Council submits that merely adopting rules of arbitration does not amount to the express determination that Section 9 seeks. It
But
seeks to establish a strong...
can
Yes,
you
Mr. Arbitrator.
incorporate, but isn't the rules part of the arbitration agreement? So it's as if, what do you mean by the term incorporation? The rule, the arbitration clause, under which you are suing, categorically says incorporation. So when you say
Indeed,
incorporation,
Mr.
whatever is in the rules forms part of the arbitration clause. And just take out the
Indeed,
relevant,
Mr.
take out the relevant clause in the SCMA rules.
Yes,
What
Mr.
does that say?
Arbitrator. Mr. Arbitrator, Rule 6.1 of the SCMA rules provides that 3 arbitrators shall be appointed unless the parties have agreed otherwise.
Yeah, so
Mr.
in the
Arbitrator,
absence of, pause there. In the absence
yes,
of an agreement, it will be 3. And the
yes, Mr.
SCMA
Arbitrator.
and the International Arbitration Act says that in the absence of an agreement, it will be 1.
Indeed, Mr. Arbitrator, but since, as you rightly pointed out, Rule 6.1 also provides for a position in the absence of agreement, it cannot be said that it expressly gives the number of arbitrators between the parties. Rather, it just it establishes the default position that the parties may resort to if there is no number of arbitrators, and therefore does not fulfill the requirement of Section 9.
What is the curial law of this arbitration?
Mr. Arbitrator, the curial law of this arbitration would be the International Arbitration Act of Singapore.
What is the law governing the arbitration agreement?
Mr. Arbitrator, that too would be the International Arbitration Agreement, since the International Arbitration Act, my apologies, since it is the
What's the difference
law of
between a
the
curial law and the law governing the arbitration agreement?
Mr. Arbitrator, the curial law, the Council believes is the law which the parties have chosen expressly to govern the arbitration proceedings. But since in the present case, while they have agreed to the rules of arbitration, they have not agreed to any law. Yes, Mr. Arbitrator.
Curial law and the law governing the arbitration, are they the same or are they different?
Mr. Arbitrator, they can be different, but they are often in many
Under what
situations the
circumstances
same.
are they different then by that logic?
Mr. Arbitrator, if, for example, the arbitration clause, the parties have agreed to the seat of arbitration in London, and they have agreed to the Indian Arbitration Act to govern the proceedings. In that case, the law of the arbitration agreement would be the law of the seat, that is the UK Arbitration Act, and the curial law may be the Indian Arbitration Act.
My understanding is, and my brother can correct me, is in this case, the curial law is the SCMA rules, and the law governing the arbitration agreement is the International Arbitration Act, and the law governing the underlying contract is English law. But
Indeed, Mr. Arbitrator. Mr. Arbitrator, apologies because based on the Council's knowledge, I don't believe that the SCMA rules can be counted as or can be labeled as the curial law.
Sum and substance is the curial law says that it defined that in the absence of an agreement to the contrary, the default position is the sole arbitrator. The law governing the arbitration agreement says in the absence of the agreement to the contrary, the default position is sorry, my apologies. The curial law says in the absence of an agreement to the contrary, the default position is a 3-man arbitral tribunal. The law governing the arbitration agreement says in the absence of an agreement to the contrary, the default position is arbitrator. But having said that, the curial law is effectively incorporated verbatim into the arbitration clause. So therefore, there is an agreement categorically between the parties which talks about a 3-man arbitral tribunal.
Indeed, Mr. Arbitrator, the Council understands what Mr. Arbitrator is saying, but the Council would like to reiterate that Section 9 requires the express number of arbitrators to be determined, and merely adopting rules of arbitration does not amount to the express number that Section 9 requires, and therefore yes, Mr. Arbitrator.
Move on to the next contention.
Thank you. Moving to the next contention, the council would like to submit that the respondents are liable for breach of contract for non-delivery of containers 1 to 5 to the claimants. In this regard, to begin with, the council submits that the claimants are a party to the contract contained in the MMT bill in two ways, both under the common law and under the Carriage of Goods by Sea Act 1992. Firstly, the claimants are party to the contract at common law by way of the doctrine of implied contract. Here, the tribunal is requested to refer to page number 4 in the arguments advanced in the written submission, footnote number 24.
Okay.
Members of the tribunal, you will find the case of Brandt versus Liverpool, where this doctrine was most famously recognized, and the facts of that case are quite similar to the present case. In the present case, since the carrier delivered the goods to the claimants and the claimants surrendered the bill of lading in return for the goods,
But
an implied
that Brandt versus Liverpool is more in the context of a consignee. You are not a consignee. You are at the highest simpliciter pledgee. You're just a holder of the bill of lading. And the first point which I want to know, and there's no quarrel with this proposition, but is this a bill of lading in a strict sense?
Indeed, Mr. Arbitrator, since the present bill of lading.
Why is it a receipt? Why is a receipt for shipment a bill of lading?
Mr. Arbitrator, that is because it fulfills the conditions that are generally seen in a bill of lading, which is that it acts as a proof of receipt of the goods. It is an original document, and it is the document against which the goods are to be finally delivered. And moreover, a receipt for shipment, MMT bill of lading, can be considered a document of title as well. So all of these factors combine together to show that the present bill.
Isn't this something to deal with land carriage? Your consignee is effectively, in fact, your customers place a delivery somewhere in the heartland of Germany, where it has got nothing to do with. So how is it? So how is it a bill of lading in a strict sense? Can a bill of lading cover land carriage?
Indeed, Mr. Arbitrator, multi-modal
land. Yes.
Indeed, Mr. Arbitrator, multi-modal combined bill of lading can include land carriage or carriage by other modes of transport. That is precisely the function of an MMT bill of lading, that it is not merely for carriage of goods by sea, but carriage by multiple forms of transport.
So what is a straight bill of lading?
Mr. Arbitrator, straight bill of lading. Am I correct in hearing you?
Yes.
Mr. Arbitrator, Mr. Arbitrator, a waybill is a document that is firstly, it is non-negotiable, and it is issued, I believe, by the carrier. And to answer your first question with regards to a straight bill of lading, it is one that is also a non-negotiable bill that cannot be further endorsed or transferred to other parties.
Okay, proceed.
Thank you, Mr. Arbitrator. Therefore, moving in this submission, the council submits that an implied contract arose between the parties, and secondly, the claimants are also a party to the contract under the Carriage of Goods by Sea Act 1992, since this act allows the lawful holder and the endorsee of the bill of lading to obtain all contractual rights to sue by virtue of Section 2, Clause 1, Subclause A. Keeping this in mind, it is to be noted that it was a term of this contract between the parties that the goods are to be delivered only to the consignee or endorsee who produces the bill in exchange for the goods. And if you may please refer to page number 10 of the hard copy and 12 of the soft copy of the case study.
Okay.
Mr. Arbitrators, you will find clause 8.2, which states this obligation of the respondents expressly that the goods are to be delivered only to the consignee or endorsee of the bill of lading. Therefore, in the present case, the trucking company engaged by the respondents by delivering containers 1 to 5 to the buyers who were not the lawful holders of the bill or the endorsees and who did not present the bill in exchange for the goods, they breached this term of the contract. Therefore, the council council submits that the respondents, by an act of their agents, are liable for a breach of contract, and therefore breach of contract for non-delivery of containers 1 to 5 to the claimants. If unless the tribunal has any reservations, the council would like to move on to the third submission.
I believe you have waived your right to take such a offense, because if you look at you have tacitly consented. This was entirely an afterthought on your part. Because you knew, or you ought to have known, that the goods are going to be delivered, you have ratified that action, and in the meanwhile, because your customer has become insolvent, you thereafter adopted a volte-face and started waiving your bills of lading.
Mr. Arbitrator, in that regard, the council submits that while the goods were indeed to be delivered to Stuttgart, as per the terms of the bill of lading, the goods were to be handed over only to the endorsee of the bill of lading, which the buyers were not in the present case. And therefore, when the bank demanded the goods, they should have been delivered to the claimants, to the bank in the present case, because they were the lawful holders and the endorsees of the bill of lading.
Okay, proceed.
Thank you.
But is there a time limit? Can you just keep sleeping over the fact that the goods are being delivered and do nothing to take delivery of your goods? At what point of time should you have gone and notified the carrier to deliver the goods to you in substitution of that? How is the carrier going to know that you hold original bills of lading?
Mr. Arbitrator, could I please ask for an extension of 2 minutes to answer that question and also wrap up the third submission? Thank you, Mr. Arbitrator. In that regard, the council submits that the claimants could only have made the demand for the goods when they knew that they would not be receiving any payment from the buyers, and that when they came to know about the solvency concerns, and indeed,
exactly. So you might have given credit to your buyers for XYZ days, right? For a few months under your contract with your customer. You're a bank, your contract with a customer. But in the meantime, what do you expect the carrier to do? The carrier takes the goods all the way to the port of discharge, thereafter carries the goods to Germany from Rotterdam. And what do you expect the carrier to do? How long should the carrier wait?
Indeed, Mr. Arbitrator, you are correct in saying that the carrier certainly performed their obligation of delivery.
Tell me the date when the goods arrived at the port of the normal port of the place of discharge, and the date where you informed the carrier to reroute it and take the goods to Germany.
Indeed, Mr. Arbitrator, that date was 3rd February, when containers 1 to 5 had been delivered to the buyers, and that is the date
when did it arrive at Stuttgart, the city in Germany? And when did you carry
Yes, Mr. Arbitrator, if you may please refer to page 5 of the soft copy of the case study, paragraph number 7. You would find in the first line that 5 trucks delivered containers 1 to 5 to the buyers on 3rd February, and on the same date, in the third line, the claimants demanded the goods. Therefore, Mr. Arbitrator, the council agrees that the demand was made on the very same day, but what the council submits here is not why the goods reached Stuttgart, but why they were handed over to the buyers who were not the endorsees and the lawful holders of the bill of lading. This was in clear contravention of the obligation of the respondents under clause 8.2. Thank you, Mr. Arbitrator. Could I please ask for an extension of 1 more minute to wrap up the final submission? Thank you, Mr. Arbitrator. Here the council submits that the respondents are alternatively liable to the claimants for conversion, that is wrongful interference with the possession of goods. This is because the claimants held the immediate right to possession of the goods by holding the bill of lading as endorsees. It is an established principle that a bill of lading is a document of title, that it is a key to the warehouse and transfers constructive possession of the goods to its holder.
Your right
in the present case,
possession of the goods doesn't give you the title to sue and tort. You're not the owner of the bill of lading of the goods.
Indeed, Mr. Arbitrator, but in order to sue for conversion, the claimant requires the right to possession of the goods, and that is present in the present case.
Just because you have no interest in the goods, apart from you are the highest of pledgee. The goods have been pledged to you, but by pledging the bills of lading, you're just a financier. You have no proprietary, you have no property in the goods to sue.
Mr. Arbitrator, for that, I would like you to please refer to the case of SS Glengarry, which has been provided in the compendium. This is on page number 25 of the compendium. The last paragraph, which has been highlighted in the left column. Mr. Arbitrator, in this case of SS Glengarry, it was the holders and the endorsees of the bill of lading who were held entitled to sue the carrier in both breach of contract and conversion. So therefore, it is submitted by the council that an endorsee of the bill of lading who holds it and therefore holds immediate right to possession in the goods can sue for conversion.
And who do you sue for conversion?
Mr. Arbitrator, that would be... Mr. Arbitrator, the tortfeasor could exactly is the trucking company who were engaged by the respondents, but since they are the agents,
sue him in conversion. Why are you suing the multimodal transfer, another party in Germany? Go and sue the person in Brazil, whoever was a trucking company who failed to maintain it.
Indeed, Mr. Arbitrator, if I could please ask for an extension of 1 more minute.
Yes, please do, please do.
Thank you. Mr. Arbitrator, I would again request you to refer to the same case, that is SS Glengarry. And if you could please turn to the next page, page 26. There the highlighted paragraphs show that where the shipping agents have misdelivered the goods, the shipping company who is the principal can be sued for the same, because the state of mind of the shipping agents was in this case held as the state of mind of the shipping company itself. In the present case, since the trucking company was engaged by the respondents to perform their functions as the carrier and to undertake the delivery that the respondents are responsible for, therefore they are the agents of the respondents, and the respondents can be held liable for their actions.
Okay.
Thank you, Mr. Arbitrator. To quickly summarize this submission, the Council submits that the three essentials of conversion were satisfied in the present case, as the respondents, by delivering containers 1 to 5 to the buyers instead of the claimants, interfered with their right to possession of the goods, and this delivery was done voluntarily, and it permanently deprived the claimants of containers 1 to 5, and therefore the Council submits that the respondents are liable to the claimants for conversion of containers 1 to 5. Unless the tribunal has any reservations, my co-counsel shall now be proceeding with the remaining issues.
Yes, that's perfect.
Thank you. Thank you so much for your time, members of the tribunal.
Good afternoon, members of the tribunal and the council on behalf of the respondents. Before I begin, could it please be confirmed if I'm perfectly audible and visible?
Yes.
Thank you. I'm counsel number 2, representing the interest of the claimants in the instant matter between Megabank PLC and Efforter Spedition GmbH. I shall be dealing with issue number 4 and 5 in 18 minutes. The council seeks permission to begin with the first issue which she shall be dealing with. Much obliged, Mr. Arbitrator. Dealing with the issue number 4, which is that the respondents are liable for damage to containers number 6 to 10, I seek to submit a threefold submission. First, that in the instant case, the respondents are liable for breach of contract. Second, that the respondents are liable for breach of Hague rules. And lastly, that the respondents cannot take the defense of clause A1. Proceeding with the very first limb of my submission in this regards, I request the tribunal to refer to page 12 of the case study, that is page 14 of the soft copy. This would be the addendum to the case study, to the bill of lading. If the tribunal is with me, the very first point in the addendum states that the parties have agreed that the cargo will be maintained at a temperature of negative 18 degrees Celsius plus or minus 1 degree Celsius at all times. However, this council contends that this particular provision was not relied with on part of the respondents. For this, I request the tribunal to refer to page 14 and 15 of the case study. This would be again 16 and 17 of the soft copy. And this is the inspection certificate. If both the members of the tribunal are with me, on points 2, 4, and 5, it can be clearly seen that in the instant case, the goods were spoiled because the temperature rose to somewhere between negative 6 and negative 8 degrees Celsius, while the goods were still...
At what point of time Where does it say that at that material point of time it was not stored? It was once prior.
Mr. Arbitrator, I'm so sorry. Your voice is breaking a little bit. I'm not able to hear you.
I said, please look at the dates. Where
Yes,
does
Mr.
it
Arbitrator.
say that at a point of time the cause and the reason because it was not stored? If you look at paragraph 4 of the surveyor's report, do you have that? In page number 15 of
Yes, Mr.
24.
Yes, Mr. Arbitrator.
Our inquiries, with one exception, produce no relevant information. You had some hearsay evidence from 3 employees of the Brazilian trucking storage company, which says that the electrical connections for frozen meat had been malfunctioning in a previous week. Now, what was this previous week? When was it? So it was not during the time when they had custody. There's not even a prima facie case of negligence.
Mr. Arbitrator, yes, Mr. Arbitrator, while I completely understand your concern, if I could just advance a 2-point argument here. First, if you could please refer to page number 7 of the case study, which is the points of defense given by the respondents themselves.
Okay, 1 second, please.
Yes, Mr. Arbitrator.
Yes, tell me.
If the members of the tribunal are with me, point number 14, the respondents have themselves agreed that the spoilage in containers 6 to 10 occurred during the transshipment at Santos. Furthermore, Mr. Arbitrator, while I completely understand your concern, it is submitted that in the instant case, it is the employees of the respondents, of the agents of the respondents themselves who were contacted, who provided the information that they were aware that they were malfunctioning and there was a possibility of malfunctioning. Furthermore, if I would, the Article 3 Rule 2 of the Hague Rules themselves states that the parties have an obligation to adopt a sound system to ensure that the goods are properly and carefully taken care of.
You have the Hague Rules. Firstly, is a Hague Rule, which are Hague Rules applicable or Hague Wisby applicable?
Yes, Mr. Arbitrator. Mr. Arbitrator, the council contends that in the instant case, it would be the Hague Rules which would be applicable because of voluntary incorporation. Mr. Arbitrator, this is because Hague Wisby Rules themselves provide for their application in Article 10. Article 10 of the Hague Wisby Rules provide for 3 instances wherein Hague Wisby Rules would be applicable to a particular case. The very first provision of Article 10 states that it would be applicable if the bill of lading is issued in a contracting state. Second, it states that that it would be applicable if the port of shipment from where the shipment is taking place is a contracting state. And lastly, if the contract itself provides either for the Hague Rules, either for the Hague Wisby Rules themselves, or for a particular legislation of a particular state providing for the Hague Wisby Rules. However, in the instant case, neither of these 3 provisions are being fulfilled, since the contracting state is Brazil, how is it
that you say the Hague Rules are applicable?
Indeed, Mr. Arbitrator.
You're saying the Hague Wisby is not applicable. I get what you're saying, but how is it that the Hague Rules are applicable?
Indeed, Mr. Arbitrator, the council contends that in the instant case, Hague Rules are applicable by way of voluntary incorporation. For that, can I please draw your attention to clarification number 42? This would be page 21 of 24 and page number 23 of the soft copy.
Clarification number 42.
Indeed, Mr. Arbitrator.
Okay.
Mr. Arbitrator, this particular clarification answers that contract says Hague Rules, which seeks to clarify that the contract expressly provides for Hague Rules. Furthermore, Mr. Arbitrator, if I could draw your attention to page number 7 of the case study, page 9 of the soft copy.
When you say, okay, page 9, contract is what? The contract of carriage?
Indeed, Mr. Arbitrator. Indeed, Mr. Arbitrator. The contract of carriage contained in the bill of lading.
Yes. And what's the other one?
Sorry, Mr. Arbitrator, I didn't catch you there.
Ask me to look at another page.
Indeed, Mr. Arbitrator. Again, page number 7 of 24. That would be page number 9 of the soft copy.
Yes.
If the members of the tribunal are with me, on point number 15, even the respondents have agreed that the incorporation of Hague Rules has been done through voluntary incorporation. That is, they have been incorporated into the contract by way of contractual incorporation.
Okay, perfect. Thanks a lot. Yeah, you answered my question.
Thank you, Mr.
Now
Arbitrator.
you've got the Hague rules in front of you.
Indeed, Mr. Arbitrator.
Please take out Article 4 of the Hague rules.
Mr. Arbitrator, if I could just get 1 second for this to load.
Yes, take your time.
Yes, Mr. Arbitrator. Mr. Arbitrator,
Okay,
I'm with you.
Now look at Article 4, Rule 2.
Yes, Mr. Arbitrator.
Q. Article 4, Rule 2Q. What did it say?
Right, Mr. If I could just read the very first line before I move on to that. Neither the carrier nor the ship shall be responsible for loss or damage arising or resulting from any other cause arising without the actual fault or privity of the carrier or without the actual fault or neglect of the agents or servants of the carrier, but the burden of proof shall be on the person claiming the benefit of this exception to show that neither the actual fault or privity of the carrier nor the fault or neglect of the carrier or servants of the carrier contributed to the loss or damage.
Yes.
Mr. Arbitrator, if I could just, if I can, I'm sorry, I'm a little confused as to what question you're asking in this regard.
So it basically so he's exonerated of liability if it is without his fault. Now you have to make out a case that there was fault. Now the point, your survey report does not categorically state that there was negligence on the part of the carrier. Your survey report says that 1 week prior to the survey being issued, it was malfunctioning. There was some hearsay evidence. It talks about other customers were complaining that the temperature was not maintained properly, but nowhere does the surveyor say that the temperature was not maintained properly, and that was the root cause of this action.
Well, I completely understand your concern, Mr. Arbitrator. Again, the council contends that point number 14 of the points of defense given by the respondent themselves have clarified that the spoilage in containers occurred during transshipment at Santos, and
but
therefore they have admitted.
they've not stated that it was because of their fault of their agent. It could be out of the inherent vice of goods. You know what inherent vice means? This is perishable goods. You see?
Indeed, Mr. Arbitrator, to answer that question, the council contends that that frozen beef, if stored at the right temperature, can last up to 3 to 4 months. Thus, it is only when the frozen beef would not be stored at the right temperature would the problem occur. In the instant case, the right temperature was
If
known
you look
to
at
the
Article 4, subclause 2M. Okay, quality or vice of the goods. So this is perishable commodity which is being shipped, and there is no evidence on record to show negligence on the part. Show me any document which shows negligence on the part of the carrier's servants. Your survey report doesn't say that. Just where does your survey report say that the carrier's agents in Brazil had to do X, they did not do X, and as a result of which the goods got contaminated? Show me your survey report which says that.
Indeed, Mr. Arbitrator. Before I answer that question, could I just clarify? You are essentially asking me to show you some evidence that the goods were not spoiled because of inherent vice, right?
Yes, I am asking you to show me evidence to show that the goods were spoiled because of negligence on the part of the carrier's agents.
Indeed, Mr. Arbitrator. For that, first,
because if you're not able to provide any evidence to establish this fact, then the provisions of the Hague Rules, Article 4, which deals with the inherent vice of the goods, and also the fact that the carrier is not privy to this, will immediately click in, which will exonerate the carrier from liability.
Indeed, Mr. Arbitrator. To answer that, again, as you have rightly pointed out, it was the employees of CRGN, that is the agents of the respondent themselves, who said that who were informed by the employees of the warehouse in Santos that there were electrical malfunctionings which were
No,
happening,
please
and
read the exact words. Please read the exact words.
that the electrical connections intended for containers of frozen meat had been
1
malfunctioning
week
in the
ago.
previous
1
week.
week ago.
Indeed, Mr. Arbitrator.
So
However,
it is not at that material point of time.
indeed,
Just
Mr.
read
Arbitrator.
paragraph 4 of your survey report again.
Our inquiries, with one exception, produce no relevant information. However, we are informed independently by 3 employees of CRGN that they had been told by the employees of the warehouse in Santos that the electrical connections.
Pause. This is clearly hearsay evidence. You know what hearsay evidence means?
Indeed, Mr. Arbitrator, I completely
What is the
understand.
probative value of hearsay evidence?
Mr. Arbitrator, while I am not exactly sure what the exact value is.
In law, hearsay evidence is not admissible as evidence. So
Indeed.
your evidence, this is surveyor saying that he spoke to employees of CRGN, who in turn spoke to somebody in Brazil. And so it's not evidence from a person who has personal knowledge. It is your surveyor talking about hearsay, what he heard from CRGN. CRGN talking about what he heard from employees. A, that's not admissible. C, B, the electrical connections intended for meat had been malfunctioning in the previous week. The mere fact that it was malfunctioning the previous week doesn't mean that at the time when it was in the custody of CRGN, the agents in Santos, it was malfunctioning. This incident took place the previous week. It did not take place at the time when they had possession of your goods.
I completely understand. Yes, Mr. Arbitrator. Sorry,
so there is no prima facie case of negligence on their part. Your surveyor's report doesn't basically make out a case of negligence. In these circumstances, immediately Article 4, Rule 2Q will apply.
Indeed, Mr. Arbitrator. However, the council reiterates that the respondents have themselves admitted that the spoilage occurred at Santos. The only way the spoilage would have occurred.
There's a difference. The fact that they have conceded to the fact that to the spoilage occurred in Santos doesn't mean that their agents were negligent in Santos. It could very well mean that this is perishable items. It could be the inherent nature of the meat, and it could have spoiled automatically.
Indeed, Mr. Arbitrator. So the only way the goods would have been spoiled at Santos would have been, only other way would have been had the goods been, had the goods have an inherent vice in themselves, right? However, what the council is contending is
and we're not concerned because Article 4, Rule 2Q basically says, I don't care. You will, if it is not negligence, that's it. They're exonerated.
Indeed, Mr.
In fact, it is even if there is a case of negligence, but the negligence is the carrier is not privy to the negligence, and you can still exonerate.
Mr. Arbitrator. Mr. Arbitrator, if you could first refer to point number 8 in points of claims.
Yes.
It clearly says that the only evidence as to the cause of spoilage. Mr. Arbitrator, this has been accepted by the defendants as respondents as well.
Points of claim. Show me that. Points of
yes,
claim.
This is page number 3.
Yes.
In this, it clearly states that the only evidence as to the cause of spoilage.
Which line? Read out the line.
Point number 8. This is 4th line, starting from the 4th line after USD 738.
Okay. The only evidence of the cause of spoilage appeared in the inspection report dated so and so. Exactly.
If I could just read it out completely. Which was to the effect that the cold store in Santos, where the meat had been stored, had been set at a temperature of -7 degrees Celsius rather than -18 degrees Celsius, and that this must have been obvious to CRGN when they delivered the meat for storage there. This particular line.
That is your pleaded case. That is your pleaded case. Now, what is their response to your pleaded case?
Indeed, Mr. Arbitrator, if you could please refer to point number 3 in points of defense, page number 6. This would be 8 of the soft copy.
Okay.
They have accepted the paragraph number 8, which clearly states that this must have been obvious to CRGN when they delivered the meat to storage there.
Yes, but they are basically accepting what your survey report says. There's no dispute on that. The point is your survey report doesn't, your own survey report, firstly is based on hearsay evidence because it is what your surveyor spoke to one person who in turn spoke to another person. But that apart, the surveyors itself doesn't say that it was at that material point of time not kept at this temperature.
Mr. Arbitrator.
Yeah, so let's go to another issue now.
Thank you, Mr. Arbitrator. Since there is paucity of time, can I just get an extension of 1 minute to wrap up my last issue? Thank you, Mr. Arbitrator. Coming on to the last issue with regards to the damages, if the tribunal has no reservations with regards to the previous.
No, I want to know why is it that there is a clear clause which exonerates the carrier from liability? Deal with that. Secondly, why don't you go and you've got an alternative efficacious remedy? You keep your colleague keeps contending on bailments, go and sue the person who's responsible.
Indeed, Mr. Arbitrator. However, it is contended in for answering your second question first with regarding to suing CRGN directly. Have I got your question right?
Yes.
Yes, Mr. Arbitrator. For that, can I please draw your attention to page number? This is page number 10 of the case study. This would be the bill of lading, page number 12 of the soft copy.
Yes.
If you could please refer to the 10th clause within the bill of lading, 10A.
10A. Yes.
It states that the MTO has himself taken responsibility for the goods from the period of time that the MTO has taken the goods into his charge till the time of delivery. Furthermore, if you could please refer to clause 10C on the top of the middle section of the page, which states that the MTO shall that particular clause states that the MTO shall be responsible for the acts and omissions of his servants or agents when any such servant or agent is acting within the scope of his employment or of any other person of whose services he makes use of for the performance of the contract, as if such acts and omissions were of his own.
Okay.
Thank you, Mr. Arbitrator. If your second question has been clarified, may I move to the point? Mr. Arbitrator, for that it is contended that in this particular case, clarification number 42 states that it is the Hague rules which apply to the contract. The precise method of incorporating the Hague rules has not been given. Therefore, it is contended that the most common method of incorporating the Hague rules, that is by way of a paramount clause, would have been used for the same. Now, if I may draw your attention to page number 15, paragraph number 63 of written submissions on behalf of the claimants, arguments advanced. And also, Mr. Arbitrator, can I get an extension of 2 minutes?
Yes, please do.
Thank you, Mr. Arbitrator.
Yes, but just to cut, because we are running out of time, the main point is that Article 3, Rule 8 of the Hague Rules applies for sea carriage. It doesn't apply for when there's a tackle to tackle. So it is permissible for carrier to lessen his obligations than the threshold stipulated in the Hague Rules. For issues other than, because the Hague Rules only applies to the tackle to tackle rule. They look at the Hague Rules. I want you to please address this issue to me.
Indeed, Mr. Arbitrator. Indeed, Mr. Arbitrator.
Period of application of the Hague Rules. Just take out that point where in the Hague Rules does it say from what point of time to what point of time will it apply?
Indeed, Mr. Arbitrator. If I could just get a second to open the Hague Rules.
Yes. Please take the time.
Article 7, I believe you are referring to, which says that nothing herein contained shall prevent a carrier or shipper from entering into any agreement, stipulation, condition, reservation, or exemption as to the responsibility and liability of the carrier or the ship for the loss or damage to, or in connection with the custody and care and handling of goods prior to loading on and subsequent to the discharge from the ship on which the goods are carried by sea.
Yes. Address me on this point, please.
Indeed, Mr. Arbitrator. However, for that, may I please request you to refer to page number 13 of the arguments advanced written submission on behalf of the claimants, citation number 122, that is the case of Mehu Food Limited versus Overseas Containers Limited.
Yes.
If the members of the tribunal are with me, in this very case, there was a combined transport bill of lading where the period of responsibility was from the time the goods were taken for delivery till the time of discharge. Here, when the carrier exercised his right to transship, it was considered as an operation in relation to carriage of goods by sea itself, and thereby the rules were held to apply to the intermediate period of storage between the two legs of sea transport. In the given case as well, we have the same period of responsibility. This is a combined transport bill of lading, and the MTO has taken the charge from the time the goods were delivered into his charge till the time of delivery. Thus, it is contended that in the instant case as well, the rules would apply when the goods were in the intermediate period of storage between the two sea legs of Santos and Rotterdam.
Perfect. Proceed.
Thank you, Mr. Arbitrator. Would you, can I get an extension of 1 minute, and would it be okay if I move on to the dam?
Yes.
Thank you, Mr. Arbitrator. Should I move on to the damages contention now, or would you like me to?
Yes.
Thank you. Thank you, Mr. Arbitrator. With regards to the contention regarding damages, the council submits that the claimants in the instant case are entitled to US dollars 596,556. For this, I shall be submitting this in two halves. First, with regards to container
what is the loss you suffered? What is the loss that you suffered?
Indeed, Mr. Arbitrator, the insurance company in the instant case, which is GVAG.
Can you quantify your loss? Can you quantify your loss? The value of the goods which were sold was $500,000. Your claim is more than $500,000. It's an admitted position that you've already received money in the sense of selling it as pet food. It was not sound, but yes, it was. You had some salvage value of the cargo. So
indeed, Mr. Arbitrator.
Credit for that.
Mr. Arbitrator, with regards to the difference amount, I believe you're talking about, that is the goods which we've already sold off. With regards to containers number 6 to 10, the council is claiming 267,406, which is the market value minus the value which we've already sold off. So we are accounting for the goods which have already been sold off.
Yes, but can you take a markup of the increase in market value of the goods? When you are today only a financier of the transaction, your loss is different from the loss which your customer might have suffered. You are not a trader. You can only, your entire case is that you have lost, assuming you're right, you have lost on your right to exercise a pledge over the cargo because of this action. So your case is against the outs. So you have opened a letter of, your case says you have opened a letter of credit for $500,000. You are out of pocket by $500,000. But for the actions of the carrier, you would have exercised the right over to make a recovery of your outstanding amount.
Indeed,
so your maximum cap of liability is only $500,000, and you have to give credit for that. So
indeed, Mr. Arbitrator,
claim is totally erroneous. You are not a trader to now look at the change in increase in price of the commodity at the time when it had to be delivered.
Mr. Arbitrator, before answering that question, can I again ask an extension of 1 minute?
Yes, please take your time.
Thank you, Mr. Arbitrator, for
the organizer are not going to like us at all. We're just letting you. Yeah.
To answer your question, Mr. Arbitrator, can I please request you to refer to page number 17, paragraph number 74 of the written submission on behalf of the claimants. This would be the arguments advanced.
Page number 17. Yeah, what about it?
If the tribunal is with me, in the case of Jag Shakti, it was clearly held that when a pledgee is deprived of the goods by the wrongful conduct of third party, the correct measure of damages is the market value of goods at the time and place of delivery. Furthermore, Mr. Arbitrator, the clause 13 of the bill of lading also iterates the same measure of damages, and thus it is contended that that MPLC in this case should be allowed to recover US dollars 329,150 from the respondents with regards to containers 1 to 5. Mr. Arbitrator, since I already answered your question with regards to container 6 to 10, that is the difference between the market value and the sound arrive value of goods, may I conclude?
No, I want another point. You have this love for the Hague rules. So please look at limitation of liability under the Hague rules. Are you aware of that provision?
Indeed, Mr. Arbitrator.
Look,
To
take
answer
out that
that,
provision of the Hague rules.
just a second, Mr. Arbitrator. Mm. Mr. Arbitrator, I believe you're talking about the one which limits the liability to £100 sterling per package or unit.
Yes.
Indeed, Mr.
5,
Arbitrator.
which is Article 4, Rule 5.
Yes,
Read out
yes,
Article
Mr.
4, Rule 5.
It states that neither the carrier nor the ship shall in any event be or become liable for any loss or damage to or in connection with goods in an amount exceeding £100 sterling per package or unit or the equivalent of the sum in any other currency unless the nature and value of such goods have been declared by the shipper before shipment and inserted in the bill of lading.
So
The
this will
declaration
clearly
is
apply. So liability is capped at this amount. You can't claim these ludicrous claims, which is.
Indeed, Mr. Arbitrator, to answer that question, the council contends that that very particular clause itself states that by agreement, the carrier and the shipper can fix another amount than the amount mentioned in this paragraph, provide that the
Show me
maximum amount is
evidence
not
of an
less.
agreement to the contrary.
Yes, Mr. Arbitrator. Before that, can I just draw your attention to one more clause within the Hague Rules itself?
Yes.
Can I just get a second, Mr. Arbitrator? Mm, Mr. Arbitrator, also Article 5 states that the carrier shall be at a liberty to surrender in whole or in part all or any of his rights and immunities. Now, this particular limitation clause would definitely be a right of the carrier. However, if I could draw your attention to point number 12. Sorry, Mr. Arbitrator, could you repeat your question
Where
and
is
also give me an
surrendered this
extension?
right of a carrier? Give me evidence of him
Yes.
surrendering his right.
Indeed, Mr. Arbitrator, if I could draw your attention to clause number 12 of the bill of lading itself, which is the limitation of liability. Within that, point number G, if the tribunal is with me, it states that the MTO is not entitled to benefit of the limitation of liability if it is proved that the loss, damage, or delay in delivery resulted from a personal act or omission or recklessly and with knowledge that such loss, damage, or delay would probably result. Mr. Arbitrator, it is contended that in the instant case, the CRGN employees, it would have been obvious to the CRGN employees that the temperature that there were malfunctions, that the
This is a case
temperature
at the
would be
highest of
affected.
ordinary negligence, madam. It's not the case of recklessness or willful misconduct where the threshold is so egregious. By your
Mr.
own
Arbitrator,
survey report, even assuming this thing took place at that point of time, it was not working at the correct temperature. There was, when you talk about recklessness and knowledge, it is in some ways akin to turning a blind eye. It's something akin to willful misconduct, which is not the case over here. It's a case of pure simple negligence, even if assuming there is negligence. I don't agree, but yes.
Mr. Arbitrator, if I could just get an extension of 30 seconds again, just to
No,
answer
please
this
take it.
last
Yes,
question.
yes.
Thank you, Mr. Arbitrator. What the council contends is that recklessness has itself been defined that it is a result where if a person is aware of the circumstances and he still unreasonably takes the risk, then he would be liable for the same in recklessness as well. And Mr. Arbitrator, in the present case, the carriers knew that they had to maintain the temperature of -18 plus or minus 1 degree Celsius. However, despite knowing that, they let the goods be stored at a place. Even if not in 100%, they did knew that there were chances that the temperature would rise and the goods would be spoiled.
Thank you.
Thank you, Mr. Arbitrator. Should I proceed to the prayer?
No, I think that's we've dealt with everything. So unless my
All
brother
right.
wants some.
All right. Thank you,
Yeah.
Mr. Arbitrator. It was a pleasure arguing before this tribunal.
Thanks.
May it please the Honorable Tribunal, Speaker 808 S1, representing the respondents today. Before I begin, I'd just like to confirm that I'm audible and visible to the Tribunal. Okay, before I begin, I'd also like to let the Tribunal know that I am keeping a little unwell, because of which I sometimes face a little breathlessness issues. So if that happens during the course of my submissions, I request the Tribunal to please bear with me and allow me a moment to catch my breath or have a sip of water. Thank you. With that out of the way, I'd first like to begin by letting the Tribunal know that I will be dealing with the first issue, which is the issue of appointment of arbitrators, as well as the second issue, which relates to the claims of the claimants related to containers 1 to 5. I'll now move on to the first issue. The respondent's first contention is that the arbitration is to be presided over by a panel of 3 arbitrators under Rule 6.1 of the SCMA rules.
Please read it out.
Now,
Please read out 6.1.
Sure, Mr. Arbitrator. Rule 6.1 reads as follows. The parties may, notwithstanding any provisions in this Rule 6, agree on the number of arbitrators and the procedure for appointment of the arbitrators, and any such agreement shall prevail over the provisions in the rules. 3 arbitrators shall be appointed unless the parties have agreed otherwise. I believe the our researcher has also pasted the relevant rule in the chat box for the perusal of the Tribunal. I just also like to point the Tribunal out to clause 2
where is
of the
the
addendum.
evidence of them agreeing to an arbitrator?
Mr. Arbitrator, if I may point you to clause 2 of the addendum on page number 13 of the page number 12.
I think you're on mute.
Speaker, you're on mute.
Apologies, Mr. Arbitrator. As I was saying, I'd like to point you to clause 2 of the addendum, which says that any and all disputes arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration in Singapore in accordance with the arbitration rules of Singapore Chambers of Maritime Arbitration for the time being in force at the commencement of the arbitration, which rules are deemed to be incorporated by reference in this clause. Mr. Arbitrator, the respondents are relying on this section to this clause of the addendum to infer the intention of the parties in this particular case.
I asked the other side also this. If there is a distinction between the curial law and the governing law of the arbitration agreement, what takes precedence over what?
Mr. Arbitrator, as far as mandatory provisions of the governing law of the arbitration are concerned, those will take precedence over the curial law. However, in the course of my submissions, I will be establishing that section 9.
So to answer your question, there is no agreement either ways. Okay, and by your own answer, the governing laws of the arbitration agreement says that where there is no where in light of the incongruity between in types of a conflict and between the curial law and governing law arbitration agreement, the governing law arbitration agreement presides, and in the instant case there is no agreement between the parties, and the governing law arbitration agreement presides to the extent that if there is no agreement to the number of arbitrators, it will be a sole arbitrator.
Mr. Arbitrator, to answer your question, I'd like to point you to Section 15A of the International Arbitration Act.
Yes, that in the chat box will be very helpful.
Yes, our researcher will be doing that momentarily.
Yes.
I'll just wait for her to do that so that I can read out the clauses for you. All right. As per Section 15A, Subsection 1, it is declared that for the avoidance of doubt, that a provision of rules of arbitration agreed to or adopted by the parties, whether before or after the commencement of the arbitration, shall apply and be given effect to in the extent that such provision is not inconsistent with the provision of the model law of this part from which the parties cannot derogate. Now, a reference to this part is a reference to Part 2 of the International Arbitration Act. And while Section 9 is part of this particular reference part, I would now establish that Section 9 will not fall under mandatory provisions. If I may direct your attention to Section 15A, subsection 5 of the International Arbitration Act. A provision of rules of arbitration is not inconsistent with the model law or this part merely because it provides for a matter which is covered by a provision of the model law, or this part which allows the parties to make their own arrangement by agreement, but which applies in the absence of such agreement. Now, subsection 6 of the same section reads as follows. The parties may make arrangements referred to in subsection 5 by agreeing to the application or adoption of rules of arbitrations, or by providing by any other means by which a matter may be decided. Now, these two subsections make it clear that in the matter of arbitration, in the matter of appointment of arbitrators, deference has been given to autonomy of the parties, and subsection 6 makes it even more clear that the autonomy is to be inferred by incorporation of the rules, which in this case is the SCMA rules, and therefore the respondents are relying on rule 6.1 to state that.
But even the SCMA rules are silent as to the number of arbitrators. The SCMA rules just say that it's again subject to the agreement between the parties. If there is no agreement, it will be 3.
Mr. Arbitrator, since in the instant case, the SCMA rules are deemed to be incorporated into the, agreement.
So exactly. So they incorporated in totality, which is subject to the agreement.
Correct, Mr. Arbitrator.
My point is there is no agreement between the parties in this case.
Mr. Arbitrator, the point that the respondents are trying to make is that in the absence of an agreement, because both Section 9 of the International Arbitration Act and SCMA rules defer to the autonomy of the parties, when there is no agreement, intention is to be inferred by the rules and not the International Arbitration Act, because Section 9 will not fall under mandatory provisions of the International Arbitration Act.
Perfect. Proceed.
Very well, Mr. Arbitrator. If the arbitrators are satisfied with my first contention, I'd like to now move on to the second contention, which is that Thank you, Mr. Arbitrator. The respondent's second contention is that the claimants were not party to the contract contained in the MMT bill under common law or carriage of goods by sea Act 1992. Firstly, the MMT bill is not a recognized document of title. It is submitted that a bill of lading's recognition as a document of title, as well as the right to sue, stems from the fact that it evidences that goods have been loaded into the ship and are ready for shipment. This was established in Lickerborough versus Mason due to a pre-existing custom of recognition of shipped bills of lading as documents of title. This was further examined in Diamond Alkali, since only received for shipment bills of ladings can be considered documents of title. There is no in Diamond Alkali, it was held that since ship bills of ladings could be considered documents of title, there is no custom of recognizing received for shipment bills of ladings as documents of title. The bill of lading in question is a received for shipment bill of lading, and therefore will not be considered a document of title as per common law. Further, while analyzing the question of whether
right now, madam, without the bill of lading or a document which your clients have issued, the carrier
I'm sorry,
issued.
Mr. Arbitrator, you weren't audible. The first part of your question.
Can you just look at the bill of lading? Let's look at the bill of lading which your clients have issued. Your clients' agents in Brazil have issued, which is in page
It's on page 9 of the case study.
Yes.
Page 11 of the
Okay, you read the top hand part. It says negotiable. Okay, what does the term negotiable mean?
Negotiable means that the bill of lading will be transferable to other parties, and if this were a bill of lading,
So what is a document of title then?
Mr. Arbitrator, a document of title is one which is negotiable, but it is the respondent's contention that the bill of lading in question does not have all the necessary characteristics for a bill of lading to be considered a document of title.
Your case is, despite the fact that it says it's negotiable, is in reality non-negotiable. Then the next point is consigned to the order of. What does to the order of mean?
It means that the bill of lading will be consigned to whoever is the endorsee of the bill of lading.
To the order of, it means FDS can consign it to A. Thereafter, A can transfer it to B. B can transfer it to C. And that's exactly why the bill of lading also says negotiable. You see?
Mr. Arbitrator, I do understand your point, but the respondent's submission is that because the bill of lading in question is not a bill of lading with the essential characteristics to be considered a document of title in common law, it will not be considered.
What according to you are the essential characteristics
Mr. Arbitrator,
for
I'd
a
like you
document
to.
of title? What is a bill of exchange? Is it a document of title? No, sorry, not bill of exchange. Sorry, a
bill of
road
lading.
carrier's transport. Isn't that a document of title?
Mr. Arbitrator, I am not sure if
Okay.
it will be considered a document of title, but I would like to point you to the case of Isha versus Allied Bank, which is a case from 1980, where the question in front of the court was whether a receipt for shipment bill of lading was in fact a receipt for shipment bill of lading as envisaged by common law. Here, they consider it was held that a receipt for shipment bill of lading must satisfy three conditions to be considered a receipt for shipment bill of lading in common law. First, it must acknowledge that the goods are at the carrier's disposal. Second, it must provide for terms on which the goods are to be carried. And thirdly, I'd like the tribunal to pay close attention to this. It states that it must state the name of the vessel by which it is intended to perform the carriage. If I may direct the tribunal's attention to page 9, the current page that we're on the case study.
Yes.
It is very clear from the face of the bill that there is no mention of an ocean vessel or a port of loading where the bill of where the goods are intended to be loaded. I am not sure if the tribunal was able to locate the exact point.
Yes, I get what you're saying. The port of loading is left blank, the vessel name is left blank.
Correct, Mr. Arbitrator. And therefore, it is our submission that even if it purports to be a receipt for shipment bill of lading, it is not a receipt for shipment bill of lading that is recognized in common law as a document of title. I will. If the tribunal has no further questions, I'll move on to the second submission, which is that neither the seller nor the respondents intended to transfer property in the bank. At common law, the transfer of a bill of lading does not always transfer symbolic possession of the goods, the latter being dependent on the intention of the parties. This was confirmed in the future request.
Transferred, counsel?
Mr. Arbitrator, we'll have to look at the fact to ascertain when exactly the property is transferred. If you'll allow me just a few more minutes, I will elaborate on the intention of the parties in this case.
So, under the Sale of Goods Act, Indian law or English law, which is Indian Sale of Goods Act, is just a copy paste from the early English law. When is property transferred?
Mr. Arbitrator, as per Section 17, Subsection 2 of the Sale of Goods Act of England, the property is transferred when the parties intended to be transferred. The parties in this case will be the seller and the buyer.
Now, in this case, it incorporated the INCO terms. Have you looked at the INCO terms?
Yes, Mr. Arbitrator. As per term
the sale contract
of
under the INCO terms, in the sale contract, when was property to be transferred?
Mr. Arbitrator, as per A4 of the CIP INCO terms, the seller delivers the goods by handing them to the carrier. This is what A4, which deals with delivery of goods, specifies. The researcher has copy pasted the relevant term that I'm referring to in the chat box.
Okay. No, this is
what is A3?
Mr. Arbitrator, I will read out A3 for the convenience of the tribunal.
Again, are these identified goods or unidentified goods?
These will be ascertained goods, Mr. Arbitrator, which is why I was relying on Section 17, Subsection 2 of the Sale of Goods Act, which deals specifically with ascertained goods.
Yeah, but then the default position is, if this is ascertained goods, property passes immediately on the conclusion of sale contract, subject to there being other clause to the contrary, unless you can show me INCO terms basically says something else.
Mr. Arbitrator, Incoterms does not specify when exactly the goods will be the property in the goods will be transferred from the seller to buyer. However, because it specifies that delivery is to deliver, the seller will be deemed to have delivered the goods when the goods are handed over to the carrier. The respondents rely on this, along with the intention of the parties, which is clear that delivery has to be made, which makes it clear that delivery was supposed to
No,
be made
that
at
what you're
Stuttgart.
talking about is risk. Risk passes on shipment crossing the ship's rail.
Correct, Mr. Arbitrator. I would like to refer the tribunal to another case that I will be referring to. If you just allow me a minute.
But how do you distinguish the case law which they have cited? Your opponents have cited a case law which says that you can sue in tort as a bailee in bailment, even though you may not have proprietary rights in the strict sense, but as long as you can show that there's an infringement of your right to possession over the goods.
Mr. Arbitrator, that contention is based on the assumption of the claimants that the bank had a special property in the goods to be able to sue in tort. I will now refer to the case of the Filiatra legacy, where the sale was made on CIF terms, which again, similar to CIP terms, the delivery is deemed to be made when the goods are delivered to the carrier by the seller. Here it was held because the sellers gave instructions to the ship owners for delivery of the goods to buyers, even though the bill of lading was made out of the order of the sellers, the property passed to the buyers on shipment of the goods by the seller and not on payment of the price or the delivery of the bill of lading. Further, to clarify, in this case, the property was held to have passed even before the bill of lading was delivered to the buyers and before the price was paid by the financing bank.
Yeah, so it actually militates against your contention, because by this logic, they, in the sense your claimants, are a bank. They made payment for on behalf of the buyers. The property was no longer with the shipper. Property again belonged to the buyers. They have pledged the goods with the buyers, and as a result of which, right now, whilst they may have proprietary rights, they have no possession over the goods. They cannot take possession of the goods.
Mr. Arbitrator, it is submitted by the respondents that the bill of lading did not act as a document of pledge in this instant case. Therefore, the bank could not have derived any rights from the bill of lading. Therefore, in the case of containers 1 to 5, the respondents were right in delivering the goods to the buyer itself as the person with general property.
Is this a straight bill of lading? Is that your argument? What is a straight bill of lading?
A straight bill of lading is one where a consignee is named and the straight bill of lading will not be negotiable. But the respondents' argument, it is a receipt. I am not entirely familiar with waybills, but I believe it is a receipt of an acknowledgement of receipt of goods by the carrier from the shipper.
Okay.
Mr. Arbitrator, the case that the respondents are trying to make here is that the bank did not derive any rights by way of the bill of lading in question. Now, if we talk about containers 6 to 10, because the bank chose to exercise its rights as pledges of the goods, the delivery was made to the bank. However, in case of containers 1 to 5, the bank did not choose to exercise its rights as pledges until after delivery was made. And as carriers, it is submitted that the respondents did not have any knowledge of the underlying intention of the parties. It only knew based on paragraph 3 as well as 4.
Relevant because you have no business delivering the goods and handing over custody of the goods to somebody without production of the original bills of lading. So whether you had, so you should have waited over there and kept it. And if it was not, you should have sold it and kept it to the credit of the party. But you can't unilaterally decide to deliver.
Mr. Arbitrator, I'd like to point you to page number 2 of the case study, paragraphs 3 and 4. And at this point, I'd just like to take a minute to have a sip of water.
Yes.
Paragraph 3 of the case study, the Honorable Tribunal. The last line in the paragraph, in this paragraph, delivery to GF's premises outside Stuttgart. On 15th December, FDS and as sellers arranged for carriage of the said beef with GMM, who acted as resilient agents, with collection of the goods by truck from a cold storage outside Curitiba and their delivery to GF's premises outside Stuttgart. This is also reiterated in paragraph 4 of the case study, where it clearly says that FDS acknowledging receipt in charge of at FDS's premises in Curitiba of 10 containers and agreeing to carry them to GF's premises in a Stuttgart industrial estate. This
There's no
clearly
dispute
establishes
with the proposition that you agreed to carry it and you delivered it to the right party. The issue is that whilst you have delivered it, the party had no right to take delivery in the first place. He may have been the lawful hold, you may be the owner of the goods. But you are by providing him possession of the goods without him providing you a document of title, you have deprived the bank of its right as a pledgee of the goods. That is the case.
Mr. Arbitrator, I'd like to reiterate the case that I had cited, the case of the Filiatra legacy, where the goods were delivered without the bills of lading to the buyer by virtue of a clear instruction by the carrier to deliver, by the shipper to deliver the goods to the buyer and not to the financing bank. This kind of clear instruction is what the respondents relied on in delivering the goods to the buyer. In this case, it was held that even though a bill of lading was issued, it didn't perform its general function as a bill of lading.
In this case, the clear instructions should have come from their customers, because this was to the order of so and so. There was to the order of the shippers. So they should have always you're always exposing yourself if you want to deliver it to a party other than what the shippers tell you. Then you have to surrender the original bills of lading and then you can deliver it to XYZ. That instruction should have come not from the shippers but from their customers. The problem is in this case, the instructions didn't come from the customers. Customers went first.
Mr. Arbitrator, first I'd like to ask for an extension of 2 minutes to answer your question and then sum up my arguments.
Yes.
Thank you. Mr. Arbitrator, it is submitted that the contract of carriage was between FTS as shippers and ES as the carrier. Therefore, instructions...
But the consignee inherits the contract of carriage. They, under Article 1.3 of the COGSA 1992, are inheriting the contract of carriage. They have the. So you should have taken the shippers irrelevant in this case.
Mr. Arbitrator, it is the respondent's submission that this particular MMT bill of lading does not fall under the ambit of the carriage of goods by Sea Act. Allow me just a few minutes to quickly take you through our submissions in that regard. First of all, there isn't a lot of judicial precedent, or there is no judicial precedent in the question of whether or not an MMT bill will be considered a bill of lading for the purposes of carriage of goods by Sea Act. I will now be relying on two commentaries. First, that cover on the question of whether a bill of lading constitutes a bill of lading under the Carriage of Goods by Sea Act 1992, argues that at common law, a bill of lading refers only to a document evidencing a contract of carriage of goods by sea, a fact bolstered by the title, of course, of the Act itself. Further, Carriage of Goods by Sea Act 1992 does not define a bill of lading. The Act does provide that it applies to a received for shipment bill of lading. However, Simon Bond, while analyzing the question of whether or not a multimodal bill of, transport bill of lading falls within the scope of COGSA 1992, stated that it will require at least an indication of the designation of the carrying ship and of receipt by the sea carrier. Now, this is also a fact that is bolstered by the case law that I had relied on earlier during my submissions, which was Isha versus Allied Bank, where they've clearly made given three conditions to be satisfied for a bill of lading to be considered a received for shipment bill of lading. Because the Act does not define a bill of lading, we will necessarily have to rely on common law to understand whether this bill falls under the ambit of the Act. Therefore, because it doesn't, the MMT bill will clearly fall out of the scope of the Carriage of Goods by Sea Act. Honorable Tribunal, I would have to ask extension of another 2 minutes. Now, if the tribunal is satisfied with my answer to your questions, I'd like to move on to the rest of my submissions.
Yes.
The rest of my submissions are with regard to the intention of the parties again. As I'd already referred to the case of the Filiatra legacy, I'd also like to establish a few facts that FDS as sellers arranged for the delivery of goods specifically to GF's premises. The commercial invoice names GF as the consignee. If I may direct the tribunal's attention to page number 13 of the case study, where the named shipper is FDS and the named consignee is GF. Therefore, and of course, also the two paragraphs that I'd referred the tribunal to, all of this combined establishes that, like in the Filiatra legacy, property and goods passes to the buyers on shipment. Further, it is submitted that where a payment is by documentary credit, the seller ships the goods in knowledge that he's going to be paid. And therefore, there is no need for him to retain the bill of lading as security of the payment. This further strengthens the argument of the respondents.
Can you repeat what you said?
Mr. Arbitrator, it is submitted that where payment is by documentary credit, the seller ships goods in knowledge that he is going to be paid. Therefore, there is no need for him to retain the bill of lading as security for the payment. This further strengthens our argument.
But now it is the other way around. But here the bank which has financed the made payment wants to be paid by its customer. Until it's paid by its customer, it's not going to release its security over there. So you deprive the bank of security.
Mr. Arbitrator, it is submitted that again the relationship of pledgee and pledger is between the buyer and the bank, and therefore in this case, while in normal circumstances, it may be it could be proven that the delivery of the bill of lading itself acted as a pledge of the goods. In this case, because the seller did not have any property to pledge to the bank, because the property had already passed to the seller, the bill of lading in itself did not act as a pledge to the bank, and therefore the bank cannot rely on the bill of lading.
Yeah, exactly. So the seller is irrelevant here. It is the buyer who has pledged his goods to the bank. Property is passed to the buyer. The buyer has pledged his goods to the bank, and you have deprived the bank of security.
Mr. Arbitrator, first of all, I'd like to ask for an extension of another 1 minute to quickly sum up. This was my last contention. Mr. Arbitrator, it is submitted that the bank chose to exercise its right as pledgee after the goods were delivered to GF. If I may direct to the tribunal's attention to paragraph 5, I believe, of the case study. Apologies, paragraph 7, page number.
We're running out of time. Go to the next contention.
Mr. Arbitrator, this was my last contention, so I just wanted to direct the tribunal's attention to the fact that MPLC only demanded goods when it felt that GF had become insolvent. There was no indication that that MPLC wanted delivery of the goods to occur at the premises decided by MPLC.
Unless if they make out a case of waiver or ratification of their actions, they are entitled to act that way. So I don't think nothing turns on it. Anyways, thanks a lot.
Thank you, Mr. Arbitrator. Much obliged.
Good evening, good afternoon, members of the tribunal. I would like to confirm that I'm audible, clearly and visible to everybody.
Yes.
I am speaker number 2, appearing on behalf of the respondent carrier ES before this honorable tribunal today. I will mainly deal with 3 contentions. First of all, I will submit before this tribunal that the Hague rules in the present case do not apply. And even if they do, they only do so by the force of contract or voluntary incorporation and not statutory force. And therefore, they must be read in consonance with the other provisions of the contract. Secondly, I would submit that even if the Hague rules apply and the clause A1 stands, there is no breach of contract with regards to the addendum, since clause A1 absolves the respondents of the liability, even though clause 1 states that the temperature had to be maintained at all times. And finally, I will submit that the claimants, if entitled to any compensation at all, will be entitled only to the amount of $500,000 and not the market value. To clarify a few facts before I begin my first contention, I would like to submit that the respondents in the present case do not dispute the fact that the damage did take place during transshipment while they were sitting in a warehouse at Santos. We submit, however, that we were not responsible for this damage and therefore not liable for it by virtue of clause A1. Before coming to that contention,
what is the remedy then, counsel? What is their remedy? They have to go all the way to Brazil and sue them. Is that what you're suggesting?
Mr. Arbitrator, in such a case, the remedy of the claimants in any case will not be against the carrier, since clause A1 was something that the parties expressly agreed to exclude the liability of the carrier. I will establish this, Mr. Arbitrator, but before I do that, I must explain.
Isn't this contradictory? Your terms of contract, isn't it contradictory? On one hand, there's a provision saying that you are liable as long as it is in custody. On another hand, the type clauses exonerate you from liability, including for gross negligence. Firstly, there is tremendous, there is incongruity. You can't reconcile these two clauses. It's so ambiguous. And pursuant to the contra preferentem rule, in right of your contradictory clauses in your own contract, we will disregard and interpret it against the parties seeking to rely on it.
Humbly disagree, Mr. Arbitrator, that the two clauses cannot be reconciled. In fact, in my third submission, I was going to explain how
the first clause which says that you are liable for all actions you while it is in custody. That was, I think, in the fixed terms of the bill of lading.
Is this clause 1 of the addendum? Which clause
is
this,
Mr. Arbitrator? The standard terms, which I think your opponents pointed that out.
Mr. Arbitrator, in any reliance placed on the standard
liability of the MTO 10, okay, base of liability, the responsibility of the MTO for the goods under this contract covers the period from the time the MTO has taken the goods into his charge to the time of delivery. You get what is this?
Absolutely, Mr. Arbitrator. The answer to this question is fairly simple. No reliance can be placed on standard printed clauses in the bill of lading if they are in conflict with typewritten clauses. For this, if I can bring the tribunal's attention to page number 12 of our written submissions of arguments advanced. Is the tribunal with me? On that page, we have cited a case of Finagra versus OT Africa Line, which has reiterated a principle which is fairly common in English law.
That case goes against you. That case, Finagra versus OT Africa, basically incorporates the Hague rules, and it looked at Article 3, Rule 8 of the Hague rules, and it nullifies such a clause.
Mr. Arbitrator, if I can just rely on this one particular paragraph they have quoted in the written submissions as well.
But look at, you have not read. Have you read Finagra versus OT Africa? How do you get with Article 3, Rule 8? Read the proposition of Article 3, Rule 8. I distinctly remember this case.
Mr. Arbitrator, the reliance on this case is not placed for the contention of the Hague rules. For that, we have separate contentions. This particular case is relied on only to show that the typewritten clauses.
That distinguish Finagra, because that, according to me, goes against you, because that categorically says anything contrary to Article 3, Rule 8 will be nullified.
Absolutely, Mr. Arbitrator. I will explain how Article 3, Rule 8 does not strike out Clause A1, if that's what the arbitrator wants me to deal with first, and then establish why the printed clauses.
Two grounds. Number one, my first point is, even assuming the Hague rules is not incorporated, this clause is unenforceable, it is unconscionable, it basically it goes against the Unfair Contract Terms Act. If it was Indian law, it will be against public policy, because it's totally you can be grossly negligent, but still you will be exonerated from liability. That's what it says. So it's unenforceable in law, according to me. Divorce, whether it is the Hague rules are incorporated or not.
Mr. Arbitrator, I will convince you on this point that it is not as broad as the claimants are seeking to make it. The responsibility of the carrier by virtue of Clause A1 is excluded only during 3 phases of the transit, namely loading, unloading, and transshipment, as is clearly evidenced in Clause A1. We submit that these 3 are the phases in which the goods were not in the direct custody and management of the respondent carrier. And the respondents,
when it is loaded and unloaded, it is in your direct custody. And in any event, you are merely a multimodal transport operator. You have subcontracted every single task of yours, be it carrying it by road, be it warehousing it, be it putting it on vessel A for the feeder service, be it the main voyage from Santos to Rotterdam. Everything is subcontracted. You have not done anything under the sun, effectively. What is it that you have on your own?
Right, Mr. Arbitrator. Should I first address the question regards to Hague rules and then this, if that's what the arbitrator prefers, or should I? Because there were 3 questions, I believe, posed by the tribunal. I want to make sure I do not miss
you
any.
can answer it any order you want to, whatever you're comfortable with.
Mr. Arbitrator, as for the incorporation of the Hague rules, the claimants have already admitted and made our job easier that the incorporated Hague rules are only voluntary in the present case and not by statutory force. Now, Professor Simon Vaughan, while relying on certain cases, has reiterated a very simple principle in his book, Shipping Law. He states that when rules such as Hague rules are contractually incorporated into a document or a contract, their provisions may be displaced by contrary clauses elsewhere in the document, subject to the general principles of construction of a contract. Similarly,
the Article 3 no late is displaced. It says other principles may be displaced. For example, you can always increase your liability. There's no problem with that. So you try to harmoniously construe 2 documents.
Right, Mr. Arbitrator.
Nothing stops you from increasing your liability.
Mr. Arbitrator, in this case, of course, nothing stops us from increasing or decreasing our liability. But Professor Simon Vaughan, as well as
you cannot decrease your liability. You can increase your liability.
I humbly differ from the tribunal in this case, and I will rely on certain cases for this point. In the Tasman Discoverer, which is a landmark judgment, it was held that the Article 3, Rule 8 of Hague Rules only prevents the carrier from contracting out of the scheme of his compulsory or paramount obligations. But there is no obstacle to the parties agreeing to a modification of the Hague Rules obligations in the exercise of the legitimate freedom.
The paramount obligation is your duty to take care of the cargo, especially in circumstances when the bill of lading on the face of it says on your face says it maintain it at 8 degrees centigrade.
Absolutely, Mr.
Whatever the temperature was. So
minus 18 degrees.
Paramount obligation. And look at Hague Rules Article 3.4, and I don't, and you know, it is underogable. So the fact that you subcontract it does not exonerate you of liability. The underlying container was not cargo worthiness. You know what cargo worthiness is?
So, Mr. Arbitrator, can you please repeat the last sentence? I couldn't hear you.
This is a case of seaworthiness, because the very container where because one of the facets of seaworthiness is cargo worthiness. The very container in which goods were stored was not fit enough to withstand the ordinary voyage.
Mr. Arbitrator, we agree that we had to maintain the temperature of minus 18 degrees Celsius. However, the words used at all times in that particular clause are to be read in consonance with the other clause, that is clause A1. We submit that when the claimants were submitting that the temperature was to be maintained at all times and that this was the responsibility of the respondents, they read this clause in isolation. It is a basic principle of English law when 2 clauses can be reconciled, which I will submit that they can be in the present case. Then no violence should be done to the application of either one. We submit that clause.
Even if it is not. Okay, proceed.
Our contention is that clause A1 being the most specific clause here will act as an exception to clause 1 of the addendum, which mandates the temperature to be maintained at all times. If I can rely on the maxim of generally as specialibus non derogant, which simply states exactly what I have just stated. If you look at clause A1, Mr. Arbitrator, it states that the respondents won't be liable only during the 3 phases in the transit which are mentioned in clause 1. While clause 1 of the addendum states that the temperature must be maintained at all times. Now, clearly, there's a conflict between the two. It is our humble submission that these 2 clauses can be reconciled by reading the more specific clause, that is clause A1, which only applies to 3 phases of the transit, as an exception to the general obligation placed in clause 1 of the addendum. Mr. Arbitrator, therefore, while these words at all times are used in clause 1, they are to be subject to the reading of clause A1. To mean that the temperature of minus 18 degrees Celsius was to be maintained at all times, the goods were in direct custody and management of the respondents. We submit that loading and unloading, as mentioned by Mr. Arbitrator earlier, is not actually conducted by the carrier and is done by the port parties, during which period, while there would be supervisory powers that the carrier has, they do not have direct custody and therefore wanted no responsibility for damage done during such periods. Similarly, the transshipment.
The issue here is not that. The issue here is not where the damage took place when the goods are under port authorities. It was
absolutely
to do with the very container did not have the necessary temperature. So it's not the port, the place where. So it is in relation to your inability to store the goods. You provided a container. The container was not cargo worthy in that sense. It's a question of cargo worthiness, which means the vessel is not seaworthy, which means you do not have any of your rights to take under Article 4 will not play because the vessel was not seaworthy.
Mr. Arbitrator,
it was shipped in 2 vessels. The container was not seaworthy. What I meant was that.
Right. Mr. Arbitrator, first of all, I would just like to clarify. I explained the provisions of loading and non-loading to explain that the intention of the parties was regarding custody.
Answer my question whether the container is seaworthy. You would look at a Hague rules, look at seaworthiness.
Absolutely. Absolutely. Mr. Arbitrator, we submit that the containers
are
fine.
The Hague rules dealing with seaworthiness, Council.
Right, Mr. Arbitrator. Just give me
what
1
does
second.
Seaworthiness say? Define seaworthiness.
Right, Mr. Arbitrator.
Do you know what seaworthiness means?
Right, Mr. Arbitrator. Article 3, Rule 1A talks about seaworthiness.
So yes. And
it only talks
about facets of seaworthiness is cargo worthiness. Do you agree with me?
Right, Mr. Arbitrator, I do.
So if you concede, so if the vessel is not cargo worthy, all these other clauses do not even apply. That's one of the most important point of Hague. You can't contract out of your obligation to make it seaworthy.
Mr. Arbitrator, I would like to clarify that the containers were not necessarily were at fault in the present case. If I can bring you to page number 15 of the case study, which is a survey report employed by the claimants themselves. It states that the problems were...
I want to also deal with one more point. Where in the bill of lading does it allow you to transship cargo?
I will show that first, Mr. Arbitrator.
Yeah, show me this. Where does it allow you to transship?
Right, Mr. Arbitrator. Just give me, Mr. Arbitrator, on page number 9, standard clauses at the back of the bill of lading. If we look at clause number 6, performance of the contract, methods and routes of transportation, it states that the MTO carrier is entitled to perform the transport in any reasonable manner and by any reasonable means, methods and routes for the transport of the goods. Furthermore, clause A1 itself talks about transshipment, so the parties were aware that transshipment would take place during the voyage.
Which clause?
Clause A1 itself talks about transshipment, Mr. Arbitrator, in addition to clause 6 of the bill of lading, which I just pointed out, which gives the liberty to the carrier to take any methods and routes of transportation and manners of transportation that it considers reasonable and necessary. Now, Mr. Arbitrator, coming to the second point, on the inspection certificate, it states that the issue was with the warehouse refrigeration and not the containers. It says that the temperature was difficult to maintain in the containers, but this was due to the fault of the warehouse refrigeration facilities. The claimants have also not sought to argue before this court that there was anything faulty with the containers. All they have stated was, and they have admitted, that the fault was of the refrigeration facilities at the warehouse, because of which it was difficult to maintain the temperature in the cargoes. We submit that the respondent carrier did all it could in maintaining the correct temperatures while it was in the direct custody, and therefore nothing was wrong with the containers and they were seaworthy as per the expectations of the Hague rules. However, this warehouse, which is not controlled by the respondents or does not belong to them, was where the damage occurred to the goods. If that answers that particular part of Mr. Arbitrator's question, I would like to go back to the argument to submit that clause A1 must be read as an exception to clause 1. Clause 1 of the addendum states that temperature is to be maintained at all times. Before this honorable tribunal, we humbly contend that this has to be read in consonance with clause A1, where the two clauses can be reconciled on a principle of harmonious construction. We submit that clause A1 makes the intent of the parties clear that the carrier would not be liable for any damage to the goods, and this express term was agreed to as a typewritten clause when the goods are not in the direct custody of the respondent, because it uses words such as loading, unloading, and transshipment, which are namely the 3 periods where the respondent does not directly perform these functions and delegates them. Relying on the earlier cases, it is submitted that paramount and compulsory obligations under the Hague rules cannot be excluded. However, in the present case, the warehouse where the goods were sitting did not have to belong to the respondent, and the respondent does not have to give any guarantee or warranty as to the refrigeration qualities in this particular warehouse. And then this part of the transit, that is transshipment, can be excluded from the scope of or the ambit of the Hague rules. If I can rely on another judgment for this. In Captain versus Far Eastern Steamship Company Limited, I'll narrate the facts of this case. And this is on page number 13 of our arguments advanced, if the tribunal would like to peruse the same. In that case, the plaintiff was advised that transshipment would take place during the transit. And the responsibility of the carrier in that case, as per their contract, was to be limited to the part of the transport performed by him on vessels under his management alone, similar to clause A1 in the present case. In those circumstances, it was held that the Hague rules were incorporated into the contract between the parties, but the part of the contract relating to holding the goods on dock awaiting transshipment was not within the ambit of the rules, because it did not relate to carriage of goods by water and as per the intent of the parties reflected in that clause. We submit that when clause A1 states that the respondents won't be liable for the goods when they're sitting on land in a warehouse that does not belong to them, they can exclude the application of Hague rules during such periods of the transit, since they do not relate to carriage of goods by water. Similarly, in the present case, as I already mentioned, clause A1 will be read as an exception to clause 1, thereby mandating the respondents to maintain the temperature of minus 18 degrees Celsius only insofar as it does not include the periods of loading, unloading, and transshipment. Does that answer Mr. Arbitrator's question, or are there any queries from the bench?
No, you can proceed. Last.
Much obliged, Mr. Arbitrator. Moving on to my last leg of my submission, if the tribunal is convinced that the respondents are not liable for damage to containers in 6 to 10, I would establish how, even if liable, the claimants are not entitled to any more than the amount of $500,000 US. For this, our first contention is the fact that in the present case, MPLC is not the one which is represented before this tribunal. It is GVAG, which is the insurer. Now, GVAG, in the present case, is suing by the doctrine or under the doctrine of subrogation, as is admitted by the claimants and as written in the case study. The respondents submit that the right of subrogation involves the right of the insurer to recover what they have paid to the assured, but in the limited sense of enabling the insurer, that is GVAG, to recoup for himself only the sums paid by way of indemnity to the assured. I will place reliance in the case of Yorkshire Insurance versus Nispet Shipping Company Limited, wherein it was held that the insurers.
I think the law of subrogation is they step into the shoes. If at all they make an additional recovery, okay, they hold it in trust for their customer. They hold it in trust for their assured. So
there's a simple answer.
Yes.
Sorry, Mr.
They are not obliged to give you credit. They are not obliged to give you credit. They are in the same shoes. They cannot appropriate the money, but that doesn't mean you are exonerated of your obligation to make payment of the additional sum. They are supposed to hold it in trust, and they can obviously that's between them and the customer or the bank.
Mr. Arbitrator, I have two simple answers to this. Number one, there's a difference between the doctrine of subrogation and the assignment of a right to sue. What the learned arbitrator is mentioning with regards to recovering more and keeping that value in trust can only be held in cases of assignment of the right to sue, which is different from the doctrine of subrogation. For this, we place reliance on Yorkshire Insurance Company, wherein it was held that in insurers' rights of subrogation are limited to the amount that they have paid to the assured and not a penny more. We submit that in the present case, if there was an assignment of a right to sue by MPLC to the insurer and a legal notice of that was given to the respondent carrier, in theory, yes, the claimants could recover more than what they have paid to the assured and keep it in trust. However, doctrine of subrogation does not allow for the same, as doctrine of subrogation only allows for preventing unjust enrichment and does not allow for the unjust enrichment of the insurer. Does that answer Mr. Arbitrator's question?
Yes.
Very well. Secondly, in alternative, we submit that even MPLC as a bank was not entitled to the market value. That would further strengthen our argument with regards to the arbitrator's question. We submit that being mere lenders and secure. Yes, Mr. Arbitrator.
What you read aloud from your para 34.
Para 34, sorry.
Of your submissions, Yorkshire Insurance, does it not say the same thing what Mr. Krishnamurthy was asking you?
One minute, Mr. Arbitrator, if I can just refer to this.
Your para 34. Is it not the same thing what Mr. Krishnamurthy was asking you? See the second sentence.
The principle does not allow. Right. Right, Mr. Arbitrator. Mr. Arbitrator, however,
the same.
Right, Mr. Arbitrator, submit that would only happen in case of an assignment of a right to sue and not subrogation. So even if in theory this was an assignment of right, which the case study does not say that it is, and no legal notice is given to the respondent as is required in an assignment of a right to sue.
See your second sentence.
Right.
Even if GVAG recovered more than 500,000, they would not be entitled to keep the excess.
Right. That would be in case, right. Right, Mr. Arbitrator, that would be a case if this was an assignment of right to sue, which we submit that it is not. But even in theory that it was, they would not be in GVAG.
You don't treat it case. That's what my learned brother is saying.
We have taken a different approach slightly to make first ensure that to explain that GVAG is not entitled, and then we'll explain how MPLC was also not entitled.
Your oral submissions are contrary to your written submission.
Not contrary, Mr. Arbitrator. The point at the second line of written submissions relates only to the theory if this was an assignment of the right, which we have not stated
Just
in
read
those
out the
exact
entire
words.
sentence.
Right. Even if GVAG recovered more than $500,000, they would not be entitled to keep the excess since the policy is a valued policy. And this rule follows from general
That doesn't
principles
deal
of
with assignment.
Mr. Arbitrator, yes, it does not mention assignment. However, that was what we wanted to reflect in the written submissions, that even if this was a theory case of assignment of right to sue, GVAG would not be entitled to keep it, which Mr. Arbitrator rightly mentioned would be held in trust. We do not dispute that. And that was the only intention of mentioning that in the written submissions. However, the main argument stands that they cannot recover over and above that amount in cases of subrogation, as is mentioned in the Yorkshire case, in the following paragraph as well in the written submissions. That particular line in the written submissions, Mr. Arbitrator, was just to show that even if this was an assignment of right, GVAG would not be entitled to keep it. And that is an admitted position of law, as Mr. Arbitrator also rightly pointed out. And we do not dispute that the same could have been given to PLC, but we do dispute the fact that there is no assignment of rights in the present case. We did not include that in our written submissions, Mr. Arbitrator, considering the fact that the case had been silent.
You are a multimodal transport operator. Are you aware of the Indian position of Section 73 of the Indian Contract Act and the Hadley versus
75.
Baxendale principle?
Yes.
What does it mean?
Yes.
What are the two limbs of the Hadley versus Baxendale principle?
Mr. Arbitrator, under Hadley versus Baxendale, it was held that the loss must have arisen in the ordinary course of the breach of the contract, and that these circumstances must have been known to both parties if liability had to be imposed on the party causing the breach of the contract.
You are a carrier. You are carrying perishable goods. Aren't you aware that this is subject to the market fluctuations? There could be an increase in price of the goods at the port of discharge. If there is this is something which is obvious. These are not special losses, which falls within the second limb of Hadley versus Baxendale, where there are special circumstances. So let's say, suppose your the consignees wanted to sell this to somebody else, and that was a contract which they entered, and they've notified you of that contract. Those losses are not recoverable. But the increase in market value of the goods is something flowing directly from your breach, your alleged breach of contract.
Correct, Mr. Arbitrator. First of all, can I request for an extension since my time is up to answer this question? Mr. Arbitrator, we submit that in the present case, the loss arising to the bank was under special circumstances. If in this case, the bank was out of the picture and GF was the one entitled to damages, to claim.
You had no clue about the loss of the bank. The loss, this is not special circumstances. The loss, what is that? How do you measure loss? Let's say this was an ordinary sale contract. Okay. The seller is being sued by the buyer. How would the buyer quantify his loss?
Right, Mr. Arbitrator, the buyer would quantify it based on the market value. We agree to that. We do not dispute that GF would have been entitled to the market value in the present case. We do dispute that the bank, being a mere financial lender on the security of goods, had to communicate special circumstances that it was going to recover the market value over and above the amount of 500,000 to the carrier. For this, I basically just have to rely on one English case.
So your point is, if the seller sues you, if the buyer sues you, your liability admittedly will be higher. Now, because a subrogated insurer or the buyer is suing you, your liability is lower. That's your case. So your liability depends on who's suing you.
Mr. Arbitrator, it does because of the fact that special circumstances have to be communicated if the party changes from the buyer to the bank, which is claiming for the loss of market value. For this, Mr. Arbitrator, if I can just rely on a case.
These are special circumstances which were not within your knowledge, which is the transaction, the dealings between the bank and the buyer. That's something which is not in your knowledge as a carrier. But what is within your knowledge is the increase in market price of the goods.
Right, Mr. Arbitrator, we submit that in this case, the bank's loss does not arise directly from the general circumstances or flows from the breach. It flows from their right to exercise their pledge as pledgee of the goods and recovering market value. Generally, a financier can only be said to have lost the money that it has put into the contract. English principle of damages is very simple, Mr. Arbitrator, in that it says it's compensatory and not punitive and must place the party in loss in the same position would have been in had the contract not been breached. Under general circumstances, we submit that this position of the financier bank would have been $500,000 since that is the money they had for the transaction. In this case, when they exercise the right as a pledge to recover market value, these circumstances had to be communicated to the respondent carrier in the present case. Furthermore, Mr. Arbitrator, carriers of goods, it has been held, are likely to possess in the ordinary course of events less detailed knowledge as to specific markets and onward contracts than the sellers and buyers to a transaction do. In order to succeed in a claim for damages of loss of profits against a carrier, the claimant must show general or special communication to that effect that they would recover the market value over and above the extent of their financial loss of 500,000. In addition to this, we submit that when in general, under English law, when there is a claim made for loss of profit, there has to be, it cannot be said to arise usual course of things, loss of profits. And therefore, these loss of profits can only be claimed where circumstances about loss of profit are made known to the party.
Not loss of profit. The claim is not loss of profit. The claim is simply difference between market value and the price of goods, which the salvage value of the goods which they got.
Mr. Arbitrator, we submit that is the element of profit which the bank is exercising. They had put a risk of $500,000 from their own money, and now they're seeking to recover $650,000 based on the market value. I apologize, $596,000 after the calculations and deductions.
Bank, as you rightly said, is not making a profit. It is nobody's case that the bank can appropriate this money.
So,
the point is, the bank can only earn when they sue. They are suing. They're not suing as an assignee, they are suing as a subrogated person, so they are suing it in the name. So effectively, the person collecting the money, theoretically speaking, in the strict sense, will still be the consignee. But the consignee will have to, after collecting the money, pay up this amount, whatever he's received to the bank. So that's between the consignee and the, that is between the bank and the, consignee and the bank.
Mr. Arbitrator, I would like to first clarify that in this particular case, GVAG is suing by subrogation, not the bank, just so that I'm on the same page as the arbitrator. And that's why the contention was that by subrogation, they cannot recover more. Even if MPLC was suing, and that, as you rightly stated, is between the buyer and the buyer is already insolvent and is undergoing liquidation proceedings in most probability. In such cases, the bank as a right could not recover more than $500,000 since that was the loss sustained by them. If that doesn't answer the question of the arbitrator, could I please ask you to repeat the question so I can address it differently?
Okay, proceed to your next contention.
Right. Mr. Arbitrator, our final contention had to do with claiming of compound interest of the claimants. Since they have mentioned, they have made no oral arguments in this regard, I will proceed on the basis of my own written submissions to submit that the claimants are not entitled to compound interest or any interest at all for that matter. The respondents submit that it is not enough for the claimants to show that the carrier had failed to comply with the duty to pay. The claimant had to also explain what it is about that duty that justifies compound interest as damages, since compound interest damages in English law are only awarded in exceptional cases. Since no loss has been established by the bank, as we already mentioned, no interest can be claimed on top of that. Furthermore, Clause 13 of the MMT Bill, which deals with the assessment of compensation in the Bill of Lading, makes no mention of any right to recover interest. It is said that such exclusion
of malfeasance, isn't compound interest also playable during when there's an element of malfeasance? And this was a clear case of malfeasance. I'm not talking of the negligence in the cargo contamination, but in relation to delivery without production of the bills of lading was a clear case of malfeasance where nobody even asked you to do it. There's an element of...
Mr. Arbitrator, we deny that there is an element. Right.
It's not just a case of negligence.
Right. Mr. Arbitrator, we deny this presence of malfeasance or the element of dishonesty, as my co-counsel already submitted that as per the intention of the parties and which she reflected through
but on a hypothetical situation that there is an element of dishonesty, you think you can claim compound interest?
No, Mr. Arbitrator, Mr. Arbitrator, the burden is on the claimants to prove that there was loss of use value of money for them to be able to claim compound interest. Furthermore, under common law principles, pre-judgment interest is never compounded in the first place. And we do not dispute that this arbitrary tribunal has jurisdiction to award interest or simple interest or compound interest. But based on the fact that no exceptional circumstances are proved by the claimant in this regard, and especially for the loss value or the loss of use value of money, which is necessary for claiming compound interest, since that was not established, they cannot be entitled to compound interest. At best, even if they are entitled to interest, the same has to be simple interest, since that stands to be in English law the most commonly awarded type of interest. And it has been held where the contract does not provide for interest or recovery of interest. If the arbitral tribunal does consider it necessary to award the same, it has to be simple, since compound interest is a special right arising from exceptional circumstances or when it is mentioned in the contract or the bill of lading itself. which in the present case we submit is absent from clause 13 of the bill of lading, which talks about the assessment of compensation for a breach of the contract. With that, I would like to conclude my arguments and ask if the tribunal has any queries with regards to any of my submissions.
Thanks.
Much obliged, Mr. It was a pleasure arguing. Mr. Arbitrator, you muted.
I had a few queries. If you say that the bank is entitled to sue only to the extent that has been subrogated, so say 500 out of 590, would the BL holder have the right to sue for the balance non-subrogated portion?
Mr. Arbitrator, we submit that the insurer and not the bank can only recover 500,000 by doctrine of subrogation, as the bank is suing in its own name, and that is not what the subrogation element is in the present case. As for the bank's right to recover more, I have already submitted that the loss did not arise under general circumstances flowing from the breach, and that special communication had to be proven by the claimant bank that it would want to recover the market value of the goods, as based on the authority cited earlier, that the carrier has to be told of the special circumstances under which a market value or excess loss has been claimed by the claimants.
Supposing that has been met, would the non-subrogated part of the claim be available to be sued by the assured?
No, Mr. Arbitrator, they have already been indemnified and have given up their rights under the insurance policy to the insurer to sue in the present case in their name. We submit that in such cases, MPLC cannot simultaneously start other parallel proceedings against the which we already submitted cannot be more than what they have already paid to the assured, since that would amount to unjust enrichment of the insurer. And that would be...
Are you not getting unjustly enriched by the fact that that insurance policy was not fully paid? Are you not gaining out of it? You're better off because of the subrogation than you would have otherwise been. You would have faced a larger liability.
Mr. Arbitrator, we submit that if in this case the insurer wanted to recover more than the market value, they had two conditions to meet. Either they could have mentioned in the insurance policy that the risk would be to the market value of the goods and not 500,000. The fact that they've mentioned an amount makes it a fixed value policy. Secondly, if they wanted to recover the market value or over and above 500,000, all they had to do was ask for the assignment of the right to sue and give a legal notice of the same to the carrier, which has not been done in the present case. In the absence of an assignment of a right to sue, by doctrine of subrogation, all that the insurer can recover is what they have paid to the assured, which would be to compensate them for the insurance that the insurance company has suffered financially. If they had to recover more, in theory, they would need a they would need an assignment of right to sue, as has been held in certain cases, and a notice had to be given to the carrier to that effect, which is not done in the present case. Much obliged. If there are no further questions, I would like to stand down.
May I please begin with the rebuttals?
Yes.
Thank you. Members of the tribunal, the council would like to challenge some of the points made by the learned counsels for the respondents. Firstly, it is contended that special property has passed to the claimants by way of pledge, since a bill of lading is a valid document of title, and the same has been confirmed for an MMT received for shipment bill as well. For that, I would like to like you to turn to citation number 83 and 85 provided on page 9 of the arguments advanced in the written submission, and many eminent jurists have supported this proposition. In any case, the question of special property does not...
Was the intention of the seller to sell the goods to the bank? No, it was always to sell the goods to the buyer. What is a contract of sale? A contract of sale is a transfer of property rights. There was no contract of sale between you and the buyer and the seller, sorry.
Indeed, Mr. Arbitrator, you are absolutely correct. The general property did pass to the buyer since by way of the sale contract, but the special property by way of pledge rested in the claimants. Further, the council submits that the question of special property doesn't arise at all.
General property and special property.
Mr. Arbitrator, the general property is the ownership rights in the goods, while the special property is only the right that a person, say a pledgee, can hold, wherein they can obtain the goods and they can use their right to dispose of the goods in case of any default by the pledger.
Okay.
Mr. Arbitrator, the Council contends that the question of special property does not arise at all, since the right to immediate possession, which is required to sue for conversion, is present in the instant case. The Council is unable to understand how the respondents have contended that there was no intention to transfer the possession, since that was the very basis of the security that the bank had obtained by being the endorsee of the bill of lading. And if the bank does
have
not...
one doubt, which I think, sorry to interject, but a very important point was made by your opponents, which is that a very document you're suing is not a bill of lading in the first place, because it's not a document of title, because you did not name the vessel. So you address that part. There was no port of loading which was named, there was no vessel which was named.
Mr. Arbitrator, in that regard, a receipt for shipment bill has also been considered as capable of passing property and constructive possession. For that, I would like you to refer to footnote number 80. And in any case, an MMT bill is recognized as a document of title. And therefore, what the Council contends is that since this bill was endorsed to the claimants, clearly they did obtain the right to possession of the goods, which is the very basis of an endorsement. Further, the fact that Stuttgart was mentioned as the place of delivery only signifies the location at which the goods were to be delivered, not whom the goods were to be handed over to. And in the case of the Huda, it was held that it is the obligation of the carrier not only to deliver against the bill, but to refuse delivery without presentation of the bill of lading, and therefore that obligation was not fulfilled by the respondents in the present case. Moreover, an MMT bill also can fall within the scope.
Don't go to the nail on the head. I think we are running out of time. So just hit the nail on the head and distinguish the points with what.
Indeed, Mr. Arbitrator, to sum up quickly, the Council submits that the Carriage of Goods by Sea Act does include within its scope an MMT bill, since it applies to any bill of lading as mentioned in Section 1. And further, the Law Commission has also recognized that an MMT bill can fall within its scope. And moreover, the fact that the respondents delivered containers 6 to 10 to the claimant signifies that they knew that the endorsees of the bill of lading had the right to delivery of the goods. Moreover, it has also been contended by them that under subrogation, the claim for damages is misconceived. However, I would like you to refer to page number 56 in the compendium, which is a document from the official website of Lloyd Institute, where it says that in case of excess being recovered, the excess amount will be distributed to the rightful insured, while the insurer only takes the amount of the insurance given. Further, it is said that
you as in are not entitled to it. It is at the highest you will hold it in credit. That is your case. Any additional amount. Okay, another very important point, which I was very much impressed with other side, is you can't claim interest if you're suing in tort. You can't claim pre-judgment interest in a claim in tort, claim in bailment. How will you distinguish that?
Mr. Arbitrator, in that case, I would. For that, I would like to.
Can you? I mean, what is the law? Can you claim pre-judgment interest in a claim in tort?
Mr. Arbitrator, the Council at the present moment would not be able to answer that question. However, I would like to.
Because as far as a bailment claim goes, XKC, you can't claim pre-judgment interest. There's no question of you getting interest in the first place, let alone compound interest.
Mr. Arbitrator, but the respondents. Yes, Mr. Arbitrator, but the respondents are also liable for breach of contract, and so with respect to breach of contract, pre-judgment interest can be claimed, and that too compound interest, as has been generally recognized that in arbitral proceedings, compound interest is normally awarded to adequately compensate the party who has suffered the losses. And for that, if you would like,
now just go to the next point. There is wrap.
Indeed, Mr. Arbitrator, and further, the Council also submits that the Council for the respondents submitted that they did not directly perform the function of storage, Santos, and other such contentions submitted by them. But again, the Council would like to reiterate and direct your attention to Clause 10, which states that the MTO is responsible for the entirety of the carriage, and therefore, since they have very clearly admitted that the warehouse refrigerators were faulty, they were under an obligation to ensure that the proper temperature is maintained even in the warehouses. With that, I believe that most of the points have been covered, and keeping in mind the paucity of time, the Council would like to conclude here.
Thanks.
Thank you. Thank you, members of the tribunal.
May it please the Honorable Tribunal, am I audible and visible?
Yes.
Okay, I will then want to the rebuttals. The first point that I'd like to address is that the claimants have claimed that an MMT bill, being a receipt for shipment bill of lading, will be considered a document of title. Now, the case that they have relied on for making this submission is on page 9 of their written submissions, footnote number 80, Marlborough Hill versus Alex Coven and Sons Limited. Now, this is a 1921 case where it was held that a receipt for shipment bill of lading will be considered a document of title, but it did not define what a receipt for shipment bill of lading is. I will now refer to the case that I had cited during my arguments itself, where I had referred to Isha versus Allied Bank, which referred to this very case to define what a receipt for shipment bill of lading is. And this current MMT bill does not fall under the definition given in the case that I have cited and the authority that I have cited, and therefore the submission of the claimants that the MMT bill is a receipt for shipment bill of lading must fail. Further, they had also cited the case of the Huda, where it was held that the carrier had a right to refuse delivery without the bills of lading. Now, there is a very major distinction between our case and the case of the Huda, which is that in this instant case, the earlier intention of the parties was to make delivery on production of the bill of lading. But later, during the course of the shipment, it was informed by the shippers to the carriers that they don't want delivery to be made on receipt of or on production of the bill of lading, and therefore there's a major difference between both these cases in question. Lastly, I'd also like to say that the delivery of containers 6 to 10 to the bank was not based on the bill of lading, but based on the fact that they chose to exercise their rights as pledges of the goods and demand delivery of the goods. Since in this instant case, the bill of lading, or the MMT bill, did not give them any rights. With that, seeing that I have my time is up, I would like to stand down if the tribunal is satisfied. Thank you.